If someone steals a car but intends to return it to the owner, did the person commit theft? We'll get the answer to this question in State versus Morris. Early one morning, Brian Gonzales went outside to start his truck to let it warm up before going to work. After starting his truck, Gonzales went back inside his house and left his truck running. While Gonzales was inside his house, Willis Morris entered Gonzales' truck without Gonzales' consent and drove away. Gonzales called the police to report that he saw someone driving away in his truck. 30 minutes later, a police officer saw Morris driving Gonzales' truck and attempted to stop Morris. Morris stopped the truck, got out of the vehicle, and ran away from the police officer on foot. Eventually, the police located Morris using a canine unit, and Morris was arrested. Morris was charged with second-degree theft as a habitual offender under Iowa state law. At trial, the court submitted a second-degree theft charge to the jury, as well as the lesser-included offense of operating a motor vehicle without the owner's consent. The jury found Morris guilty of second-degree theft. Morris appealed to the Iowa Court of Appeals. Morris argued that the state failed to prove an essential element of theft involving a motor vehicle because the state did not provide sufficient evidence that Morris intended to permanently deprive Gonzales of possession of his truck. The Court of Appeals agreed with Morris and reversed Morris's conviction for theft because there was a lack of sufficient evidence to uphold his conviction. The court held that the mere fact that Morris took Gonzales' truck without Gonzales' consent didn't give rise to an inference that Morris intended to permanently deprive Gonzales of his truck. The state appealed to the Iowa Supreme Court.